The Constitution of India, Part 5, The Union, Chapter 2. Parliament, Procedure in Financial Matters. Article 115, Supplementary, Additional or Excess Grants. Subclause 1. The President shall, a. If the amount authorized by any law made in accordance with the provisions of Article 114 to be expended for a particular service for the current financial year is found to be insufficient for the purposes of that year, or when a need has arisen during the current financial year for supplementary or additional expenditure upon some new service not contemplated in the annual financial statement for that year, or, b. If any money has been spent on any service during a financial year in excess of the amount granted for that service and for that year, cause to be laid before both the Houses of Parliament another statement showing the estimated amount of that expenditure, or cause to be presented to the House of the People a demand for such excess, as the case may be. Subclause 2. The provisions of Articles 112, 113 and 114 shall have effect in relation to any such statement and expenditure or demand, and also to any law to be made authorizing the appropriation of monies out of the Consolidated Fund of India to meet such expenditure or the grant in respect of such demand as they have effect in relation to the annual financial statement and the expenditure mentioned therein, or to a demand for a grant in the law to be made for the authorization of appropriation of monies out of the Consolidated Fund of India to meet such expenditure or grant. Article 116, Votes on Account, Votes of Credit and Exceptional Grants. Subclause 1. Notwithstanding anything in the foregoing provisions of this chapter, the House of the People shall have power, a. To make any grant in advance in respect of the estimated expenditure for a part of any financial year pending the completion of the procedure prescribed in Article 113 for the voting of such grant and the passing of the law in accordance with the provisions of Article 114 in relation to that expenditure, b. To make a grant for meeting an unexpected demand upon the resources of India when on account of the magnitude or the indefinite character of the service the demand cannot be stated with the details ordinarily given in an annual financial statement, c. To make an exceptional grant which forms no part of the current service of any financial year, and Parliament shall have power to authorize by law the withdrawal of monies from the Consolidated Fund of India for the purposes for which the said grants are made. Subclause 2. The provisions of Articles 113 and 114 shall have effect in relation to the making of any grant under Clause 1, and to any law to be made under that clause as they have effect in relation to the making of a grant with regard to any expenditure mentioned in the annual financial statement, and the law to be made for the authorization of appropriation of monies out of the Consolidated Fund of India to meet such expenditure. Article 117, Special Provisions as to Financial Bills. Subclause 1. A bill or amendment making provision for any of the matters specified in subclauses A, 2, F, of Clause 1, of Article 110 shall not be introduced or moved except on the recommendation of the President, and a bill making such provision shall not be introduced in the Council of States, provided that no recommendation shall be required under this clause for the moving of an amendment making provision for the reduction or abolition of any tax. Subclause 2. A bill or amendment shall not be deemed to make provision for any of the matters aforesaid by reason only that it provides for the imposition of fines or other pecuniary penalties, or for the demand or payment of fees for licenses or fees for services rendered, or by reason that it provides for the imposition, abolition, remission, alteration or regulation of any tax by any local authority or body for local purposes. Subclause 3. A bill which, if enacted and brought into operation, would involve expenditure from the Consolidated Fund of India shall not be passed by either House of Parliament unless the President has recommended to that House the consideration of the bill. Procedure generally. Article 118, Rules of Procedure. Subclause 1. Each House of Parliament may make rules for regulating, subject to the provisions of this Constitution, its procedure and the conduct of its business. Subclause 2. Until rules are made under Clause 1. The rules of procedure and standing orders in force immediately before the commencement of this Constitution with respect to the legislature of the Dominion of India shall have effect in relation to Parliament, subject to such modifications and adaptations as may be made therein by the Chairman of the Council of States or the Speaker of the House of the People, as the case may be. Subclause 3. The President, after consultation with the Chairman of the Council of States and the Speaker of the House of the People, may make rules as to the procedure with respect to joint sittings of, and communications between, the two houses. Subclause 4. At a joint sitting of the two houses, the Speaker of the House of the People, or in his absence such person as may be determined by rules of procedure made under Clause 3, shall preside. Article 119, Regulation by law of procedure in Parliament in relation to financial business. Parliament may, for the purpose of the timely completion of financial business, regulate by law the procedure of, and the conduct of business in, each House of Parliament in relation to any financial matter or to any bill for the appropriation of monies out of the Consolidated Fund of India, and, if and so far as any provision of any law so made is inconsistent with any rule made by a House of Parliament under Clause 1 of Article 118 or with any rule or standing order having effect in relation to Parliament under Clause 2 of that article, such provision shall prevail. Article 120, Language to be used in Parliament. Subclauses 1. Notwithstanding anything in Part 17, but subject to the provisions of Article 348, business in Parliament shall be transacted in Hindi or in English, provided that the Chairman of the Council of States or Speaker of the House of the People, or person acting as such, as the case may be, may permit any member who cannot adequately express himself in Hindi or in English to address the House in his mother tongue. Subclauses 2. Unless Parliament by law otherwise provides, this article shall, after the expiration of a period of 15 years from the commencement of this Constitution, have effect as if the words are in English were omitted therefrom. Article 121, Restriction on discussion in Parliament. No discussion shall take place in Parliament with respect to the conduct of any judge of the Supreme Court or of a High Court in the discharge of his duties except upon a motion for presenting an address to the President praying for the removal of the judges hereinafter provided. Article 122, Courts not to inquire into proceedings of Parliament. Subclause 1. The validity of any proceedings in Parliament shall not be called in question on the ground of any alleged irregularity of procedure. Subclause 2. No officer or member of Parliament in whom powers are vested by or under this Constitution for regulating procedure or the conduct of business, or for maintaining order, in Parliament shall be subject to the jurisdiction of any court in respect of the exercise by him of those powers.